Welcome to my YouTube channel. My name is David Okon. I'm talking about work in the United Kingdom, and if you have watched this video, watch it alongside the rest of the video along this series, which I've been talking about income, and I'll talk about pay and work in the United Kingdom. I'll talk about income, and also when I talk about topics in the UK, I'm also talking about topics across the globe because they are similar. Check on your government website in your country, whether you're in Africa or elsewhere or in Europe, America, is quite similar to what we find in the United Kingdom. We are going to look at money payments for different purposes. It's a continuity in terms of what we talk about when we look at certain categories of payments of money, and we look at certain period of time and what they mean with the Department of Work and Pension, and also how claims works, and we're looking also at part-time work in terms of certain rights and privileges in terms of income, where one income from work, from employment, part-time or otherwise, in relation to the Department of Work and Pension in terms of income, are compared, such as the period over which the Department of Work and Pension takes into account certain earnings from part-time work, other than compensation payments, and when this period ends. And these are looked at in terms of time frames to determine certain rights and obligations claimants and part-time work ending on or after the first day of their entitlement to income support, income-based job seekers allowance. These are money given by the Department of Work and Pension for one reason or another. Looking at job seekers allowance, contribution-based job seekers allowance, which are the hard final payment of earnings. That does not count as compensation. You look at compensation, are you looking at also final payments in terms of comparison, and which is not disregarded for purposes of means tested benefit, and when it is taken into account or otherwise over the following period. And however, that there are special rules if the claimant gets different type of earnings for overlapping period. When periods overlap, and they may get different types of earnings, and the periods may look something like if the payment is monthly, a period equal to the number of weeks from the date on which the payment is treated as paid to the date immediately before the date on which the next monthly payment would be treated as paid, or if the payment is not monthly, the period for which the payment is made, unless it is not made for any particular period. These are actually timing of payments which may or may be treated as payment or otherwise for assessing payments made by the Department of Work and Pension. We are looking at the relationship between payment from work and also from the Department of Work and Pension, as in normal payment, work-related payment, and also benefit-related payment. I've talked about benefit previously, and also talking about income in relation to employment, and the details. If you watch this video and others, they are connected. Leave a comment below. If you haven't subscribed to this channel, subscribe. To support the channel, subscription is free, it takes seconds, and also we are work in progress. We are struggling slightly for visibility, and we are on our way to growing, to expand, so that we reach more people, the more the merrier. And leave a comment below. At every opportunity watching this video, share with family and friends. Thank you so much. So if the claimant's payment of money is not paid for any particular period, it is taken into account for a period of weeks. The Department of Work and Pension DWP calculates by dividing the claimant's net earnings by a certain figure. These are some of the ways laws are crafted in this country, the employment law, what the law looks like in your country. This is employment law in terms of pay, and now assessments are made for purposes of determining whether or not certain group of people working in certain ways can or cannot get certain type of help from the government in terms of benefit. So we look at weekly amounts of income support or job seeker allowance that the claimant would have been entitled to if the payment of earnings are not been made, and any earnings disregarded and any earnings disregard to which the claimant would have been entitled. So we look at more about the period covered by income for income support and job seeker allowance, welfare benefits, and tax credit and book. Stay tuned, continue watching. So payment referred to in previous two paragraphs that count as earnings rather than compensation. We talk about earnings, we talk about compensation, which are strictly treated differently, but they are types of income. So we look at last wages or salary or money in earned. For income support, pay in lieu of notice holiday pay that is due to be paid up to 4 weeks after the claimant's employment ended. We talk about claimant, somebody who is working, who has probably stopped working, but there are payments involved which affect their income or capital for purposes of benefit. So we're looking at compensation for unfair dismissal awarded by an employment tribunal. For income support, payment in lieu of remuneration. Remuneration is when you are paid for something you have done. In terms of benefit, work-related benefit, there are special rules for working out the period over which the following payments are taken into account. Payments that count as compensation for income support. Payments that count as compensation for job seeker allowance. Payment if the claimant gets different types of earnings for overlapping period. In this case, there are special rules for working out the total period over which their earnings are taken into account. We're also looking at what happens if the client gets different types of earnings for overlapping period. We are talking about overlapping periods. We're looking at different types of earnings for overlapping periods. So the claimant gets different kind of earnings from the same employer when they leave work. We're talking about leaving work, and they are not disregarded. It is easy to work out the period over which each type of earnings is taken into account, and then add all these periods together to work out the total period. Talk about total period. The different kinds of earnings are taken into account, one after another, in a certain order of priority for this total period. Talk about order of priority in making considerations. For income-based job seekers allowance (JSA) and contribution-based JSA, the order of priority is earnings normally derived from employment, then any compensation payments, then any holiday pay that was due to be paid within 4 weeks, the date on which the client's employment ended. We're talking about ending work. For income support, the order of priority is earnings normally derived from employment. Then any pay in lieu of remuneration or pay in lieu of notice. Then any compensation payment. Then the holiday pay that was due to be paid within 4 weeks of the date on which the client's employment ended. So look at any earnings taken into account according to the rules. The previous two paragraphs are taken into account from the earliest date on which any of them is taken into account. The sections in this document about the different types of final payment may help you work out which ones count as earnings. Some do not count as earnings, others count as earnings for purposes of one benefit or another. For example, an income support claimant's part-time work is terminated without notice on the 23rd of August 2007, which is after the date of their claim. They claim and then they are terminated. The claimant receives a normal week's earnings, then 1 week in earn, 4 days holiday pay, and 2 weeks pay in lieu of notice for the 23rd August 2023. We're talking about formula. These payments are all different kinds of earnings, but they are not disregarded because the claimant's part-time work ended after the first day of entitlement to income support. They were already entitled to income support. They are therefore taken into account as earnings. The period over which these different types of earnings would not be taken into account overlap, so they are taken into account as follows for a total period of 4 weeks and 4 days. The earnings are treated as paid on Wednesday, 22nd August 2007. The normal week's earnings and the week in hand are taken into account. First, as these are earnings normally derived from employment, they are taken into account for the 2 weeks from Wednesday, 22nd August 2007 to Tuesday, the 4th September 2007. There is no payment that counts as compensation for income support purposes, so the 2 weeks pay in lieu of notice are taken into account. Next, for the 2 weeks from Wednesday, the 5th September 2007 to Tuesday, 18th September 2007. The 4 days holiday pay is taken into account. After this, for the 4 days from Wednesday, 19th September 2007 to Saturday, 22nd September 2007. So to give you a picture of what they are trying to talk about, the timing of one payment or another, which are actually taken into account in a fairly systematic way to support valuing or even assessing one benefit or another in relation to payment, especially final payment, treated in one way or the other. Thank you so much. Continue watching. Stay tuned. There are cases, if you go online, which help illustrate this point in fair detail. If you're interested in employment law, especially pay in this respect, visit gov.uk and also a public website of Citizens Advice or ACAS. I've spoken about this website. They are extremely important, and the value of understanding employment information, employment law, employment policy information is to empower individuals who live in the United Kingdom or elsewhere, because this information is important. People work for a living often, and if you are disputing in one way or the other, perhaps with the employer or with Department of Work and Pension or any of the government department, maybe tax offices, then you tend to know one thing or another independently. It's a type of empowerment, especially given now when we are struggling more and more to finance public service in the United Kingdom and also across the globe. It's a similar situation involving similar systems across the globe. And there's something known as globalization. I've been repeating this point because they are very relevant and critical in the discussion for it to make sense at all. And the value of this process is actually acquiring knowledge and skills which is needed. It's a necessity because for most people they cannot access justice anymore. Some of these things involve going to employment tribunal or courts to resolve a dispute. If you don't have information, if you don't have experience, you will lose the case and you won't even be able. It's so costly. Even if you are presenting yourself, sometimes you have to pay. If you lose the case, you have to pay the cost of the people you are disputing with. So this is an issue you can take up with your member of parliament if you're in the United Kingdom in relation to employment law, employment rights, and obligation in terms of accessing justice. Because part of the reason of actually going through this to demonstrate to you the complexity of these materials. Everywhere you go, the complexity is always the same. And stay tuned, continue watching. Thank you so much for your participation in this project. So let us look at rights of employees when an employer becomes insolvent. We talk about insolvency. Leave a comment below if you know anything about insolvency. So we are in England, and also this information also relates to Northern Ireland, Scotland and Wales. Thank you so much. Stay tuned, continue watching. So we look at employer becoming insolvent, employer applying for a company's house for strike off, and the client owed but any money, whether or not the client is owed any money under these circumstances. How can the client recover any money owed, claiming from the redundancy payments service, registering as a creditor of the business, and all the other elements of this issue. So you talk about employer becoming insolvent. Under these circumstances, it may not always be clear whether or not a company has gone into receivership. So you look at more how to find out if a company has gone into receivership. So a receiver or liquidator has been appointed. So when a business has become formally insolvent, a receiver or liquidator may be appointed. The receiver or liquidator will decide whether to keep the employees on or dismiss them. Stay tuned, continue watching. Thank you so much. So if the receiver or liquidator is appointed by the court, this will automatically bring the contracts of employment to an end. If the receiver or liquidator wishes to keep on an employee in order to keep the business running, the employee will be offered a new contract, and the receiver or liquidator may be the new employer. In such cases, the transfer of undertakings regulations may apply. More about transfer of undertaking regulations. We talk about regulation, we talk about the law as derived from Parliament in the United Kingdom. If the company is worn up voluntarily, that is not by a court order. The liquidator who is appointed will usually be considered to be acting as an agent of the company. If the liquidator wishes to keep on an employee, the existing contract for employment will usually continue to be in force. However, the liquidator could end the existing contract and offer the employee a new contract. So if the liquidator were found to be the new employer, the transfer of undertaking regulations may apply. So talk about the transfer of undertaking regulations. These are rules involving when there is a liquidation in process. You can look more about transfers of undertaking regulation. Receivers and liquidators are liable only for rights an employee has accrued since the date the receiver or liquidator was appointed. It is common when a receiver or a liquidator is appointed for them to write to all employees disclaiming liability for any rights an employee had accrued under the employment with the previous employer, such as pay in lieu of notice, holiday pay, and pension contribution. These claims would continue to be against the former employees. Stay tuned, continue watching. Thank you so much.
MVC record.
Brava Jesus on the beat.
So we're looking at a receiver or liquidator when one has not been appointed. So a receiver or liquidator will not have been appointed if the business is ceased trading, but has not been formally wound up. In this situation, the client will have to take any action against the employer direct, or will have to think about whether to take action to wind up the employer's business in order that a receiver liquidator is appointed, but the client may be able to claim statutory redundancy pay from the Redundancy Payment Service, RPS. Stay tuned, continue watching. So when there is a company voluntary arrangement to look at, in some circumstances there might be a company voluntary arrangement, CVA, in place. This is a legally binding agreement which deals with the company's debts. A proposal will have been made to all the creditors, and if it is approved, it will bind all the creditors, including those who voted against it. An insolvency practitioner acting as a supervisor will be appointed to oversee the implementation of the arrangement by the directors. Employees owed money will be notified of the meetings to decide whether the CVA should be put into place. Under the provision of the CVA, the employee has no automatic right to be considered as a preferential creditor. If a supervisor has been appointed, the employee can use them to claim money owed from the Redundancy Payment Service if the debt is one covered by the service. Stay tuned, continue watching. Thank you so much. So the employer has applied to company house for a strike off. So if an employer ceases trading, they may apply to company's house for the company to be struck off. If the registrar of company's house agrees to this, then the company is struck off, but does not become insolvent, and no receiver or liquidator is appointed. Once the company is struck off, it ceases to exist, and there is no legal entity which an employee can take action against. If an employee wishes to take action against the company and believes that the employer may make an application for strike off, they should write to company house informing the registrar that they are owed money or as a potential claim for damages against the employer, requesting that any application for strike off be refused. They should only usually do this where they want to obtain an employment tribunal judgment that they are owed money by the employer, so that they can then apply to put the company into liquidation to recover the money they are owed from the redundancy payment service. Otherwise, an application to strike off is a likely indication that the company has no assets and there is no point in the employee pursuing the matter. Stay tuned, continue watching. Thank you so much. So if the employee is taking action against the employer for statutory redundancy pay they are owed, and as a successful tribunal judgment, then if they send a copy of the judgment along with the RPI form and a copy of the employer's application to strike off to the redundancy payment scheme, it will pay them the statutory redundancy pay they are owed. Stay tuned, continue watching, leave a comment below. If you haven't subscribed to this channel, please subscribe. To support the channel, subscription is free and it helps to grow the channel. Thank you so much. Click like, click notification bell, and if you watch this video, share with family and friends. Thank you so much. If the client is owed money under these circumstances, the client who is dismissed following the insolvency of a business will probably be owed some money. If the business is transferred to a new owner, the transfer of undertaking, the regulation may apply to protect the rights required by the client in the previous employment. Thank you so much. Stay tuned. Continue watching. You can look more about the transfer of undertaking regulations. A client dismissed because of the insolvency of the employment may be owed basic pay, holiday pay, bonuses, and commission, overtime pay in lieu of notice, maternity pay. You can look more about statutory maternity pay as well. Redundancy pay, compensation awarded by the employment tribunal, sick pay, looking also more about statutory sick pay. So a client who is a member of an occupational pension scheme may also be concerned about contributions to the pension scheme and their future pension rights. Stay tuned, continue watching. Thank you so much. So therefore, how can the client recover any money owed? Receiver, liquidator, supervisor has been appointed. Once an employer is insolvent and the receiver, liquidator, or supervisor is appointed, the client can recover any money they are owed by using the receiver, liquidator, or supervisor to claim it from the redundancy payment schemes. If the debt is one recovered by the RPS redundancy payment service and registering as a creditor with the receiver, liquidator, or supervisor if the debt is not covered by the redundancy payment service. Receiver, liquidator, supervisor are not being appointed. If the receiver, liquidator, or supervisor has not been appointed, the client cannot usually use the redundancy payment service. They will either have to sue the employer or make them insolvent in order to get the money they are owed. However, if the client is claiming statutory redundancy pay, they can claim it from the redundancy payment service, even though the receiver, liquidator, or supervisor has not been appointed. Stay tuned, continue watching. Claiming from the redundancy payment service. If an employee is owed money by an insolvent employer and has had their contract of employment terminated either because they have been dismissed or because they have resigned, they may be able to claim the payment for money owed by the employer from the redundancy payment service. The employee should normally claim through the receiver, liquidator, or supervisor, who will pass the claim to the redundancy payment service, except for certain debts which are handled by RM Revenue and Customs HMRC. An employee can claim the following: arrears of pay, including guarantee payments, contractual maternity or contractual sick pay, pay in lieu of notice, holiday pay, basic award, unfair dismissal, or protective award made by an employment tribunal if the employer has failed to inform or consult the employee's representative about a collective redundancy, reasonable reimbursement of apprentices or trainee solicitors' fees or premiums. These are not subject to the maximum weekly limit and paid contribution from the employer to an occupational pension or pension, personal pension. Stay tuned, continue watching. Thank you so much. So if an employee is owed a statutory redundancy pay, they can also claim this from the redundancy payment service. If the employer is solvent, the employee could also claim it through the receiver, liquidator, or supervisor, in addition to the debt listed in the previous paragraph. Claims for unpaid statutory sick pay, statutory maternity pay, statutory maternity pay, paternity pay, statutory adoption pay, and statutory shared parental pay are dealt with by HMRC. More about statutory sick pay, more about statutory maternity pay, more about statutory paternity pay, more about statutory adoption pay, more about statutory shared parental pay. Thank you so much. Stay tuned. Continue watching. Pay arrears. Pay includes commission, overtime, bonuses, guarantee payments, and contractual maternity or sick pay. Expenses are not included in pay. The client can only claim net pay after deduction for tax and national insurance, and can only claim up to a maximum of 8 weeks pay. Stay tuned, continue watching. Leave a comment below, let me know your thoughts on these matters. So the client may not receive all the payment, the pay they are owed, as there is a maximum weekly limit that can be paid out of the redundancy payment service, irrespective of how much the client earns. The maximum weekly limit is applied before deduction for tax and national insurance, so the client will be in effect receive less than the maximum weekly limit for each week's pay. So if the client works part-time or is only owed part of the week's pay, the maximum weekly limit will be applied pro rata. For example, a client who normally works 2 weeks, 2 days a week, will be able to claim wages up to 2/5 of the maximum weekly pay. Stay tuned, continue watching. Thank you so much. So let's look at pay in lieu of notice. So most clients will have a statutory right to a minimum period of notice. A client will be able to obtain a payment from the redundancy payment service equivalent to that statutory and to that statutory entitlement if the employee is insolvent. Therefore, there is a maximum weekly amount of pay that can be claimed. Thank you so much. More about which employees have a right to a minimum period of notice. More also about maximum amount of weekly pay. So when an employee is insolvent, he is therefore insolvent if a winding up order has been made or a resolution for voluntary winding up has been passed, or the company is in administration, or a receiver, or in England and Wales, a manager of the company's undertaking has been appointed, or in England and Wales, possession has been taken by or on behalf of the holders of any debentures secured by a floating charge of any property of the company comprised in or subject to the charge, or if a voluntary arrangement proposed in the case of the company has been proved under Part 1 of the Insolvency Act 1986. So the Employment Appeal Tribunal has held that a client will have to prove that one of these events has occurred in order to be able to claim notice pay from the redundancy payment service. They can do this by making a search at company house. Therefore, the redundancy payment service will take off the from the company any money the client earned if they started a new job during the minimum notice period, universal credit, job seekers allowance, or income support received or could have claimed during or could have been claimed during the minimum notice period, if there is evidence that the client could have got another job but failed to take the job. The amount of any wages they would have received will be deducted from the payment. If a client has a contractual right to a longer period of notice, they cannot claim a payment for this additional period from the redundancy payment scheme. To stay tuned, continue watching. Thank you so much. To claim the money, they will have to apply to the receiver or liquidator as a creditor. So looking at holiday pay, the client can claim up to 6 weeks holiday pay. This may be for holidays taken but as yet unpaid, or for accrued holiday pay. Accrued holiday pay is calculated as the holiday earned but not taken in the 12 months immediately before the business became insolvent following an employment tribunal appeal tribunal decision. The insolvency service will include contractual commission and regular voluntary overtime in the holiday pay. This decision affects anyone who received the holiday pay from the insolvency service. If your client applied for holiday pay on or after the 1st of August 2021, the insolvency service will contact them directly to ask for evidence of what extra payment they might be entitled to. If your client applied before the 1st of August 2021, they should contact the insolvency service. The insolvency service will only take extra payments if the employee said the RP1 form that they were that they were entitled to contractual commission or details of their payment, included regular voluntary overtime. If they didn't, they can't make a claim. Now, stay tuned, continue watching. You can find out more about who can claim an extra payment on gov.uk. Redundancy pay. Thank you so much. Stay tuned, continue watching. If your client could be entitled to a statutory redundancy payment, if they could be in entitlement, if their employer goes out of business, stops trading, can't afford to pay them. Stay tuned, continue watching. So they will need to meet the qualifying rule for statutory redundancy payment. Stay tuned, continue watching. Thank you so much for your patience for watching. However, they get their statutory redundancy payment. They are getting depending on whether their employer has gone into formal insolvency. An employer goes into formal insolvency when they go into liquidation, go into administration, enter a company voluntary arrangement, go bankrupt if they are an individual. An employer can choose to go into formal insolvency or be forced into it by a creditor. Stay tuned, continue watching. Thank you so much. So looking at a situation where the employer is in formal insolvency. So someone should claim their statutory redundancy pay from the redundancy payment service. In this example, an employer and employee. So they can also claim other payments they are owed, like wages, notice pay, pay in lieu of statutory paid holiday. So if an employer is in informal insolvency, then the client must first make a claim to the employment tribunal for statutory redundancy pay. When they have the tribunal judgment saying they are entitled to it, they can apply to the redundancy payment service. If the employer owes them other money, like wages, notice pay, pay in lieu of statutory holiday pay, and then the client can claim tribunal, can make a tribunal claim for those amounts too. However, even if the tribunal agrees they are owed those other amounts, the PRPS can only pay the statutory redundancy pay. The employer is in informal, if the employer is in informal insolvency. Stay tuned, continue watching. Thank you so much.
Some see the original, mighty the god, the magical radical. Hey, representing my magical, young Jose come million. Amigo wacha, that difta, kina teach me can you amigo kopa. That wacha, kina damage me can you amigo wacha. That difta, kina teach me can you amigo kopa. That difta, kina damage me can you. That's the camera. Every day I call you, my door, you're my treasure. Baby, got your machina, yo. If I be quacking on you, but it's about your cola. Baby, got the machina. Baby, got your quara. You must say banana. You must say banana. You must say banana. Baby, got your tema, come a quack.
It is worth claiming the other payments, therefore. The employer goes into formal insolvency before the tribunal issues its judgment, and then the client can ask for the claim to be paid or stayed. They can then claim all the payments they are owed from the RPS, Redundancy Payment Service. when they are received from the redundancy payment service, they can withdraw their tribunal claim. If the employer goes into formal insolvency after the tribunal has issued its judgment, then the client can claim the other payments from the redundancy payment service. They should make a separate application for them. Thank you so much. Stay tuned. Continue watching. So a group of employees could apply to have their employer put into formal insolvency. Applying costs money, but it would let them get the other payments from the redundancy payment service as well. More about how to put a company into formal insolvency, how creditors can make an individual bankrupt. There is a time limit on how much, or there is the limit of the amount, how much the weekly pay can count when calculating the amount of statutory redundancy pay. We're looking at maximum amount of a week's pay that counts. If you want more on this, you can access the internet to find out more. So a client has if a client has a contractual right to more redundancy pay than the amount given by statute, they cannot claim the extra amount from the redundancy payment service. To recover the difference, they will have to make a claim to the receiver liquidator as a creditor. Basic and compensatory awards from the employment tribunal. So if an employment tribunal has made a basic award to a client and the employer has not paid it, the client can claim the award from the redundancy payment service through the liquidator or receiver. Basic awards cannot be paid direct from the RPS. The employer must be formally insolvent, which means a liquidator receiver must have been appointed for the RPS to pay the award. A compensatory award cannot be claimed from the redundancy payment service. In order to receive a compensatory award from an employer, the client will have to make a claim to the receiver liquidator as a creditor. Stay tuned. Continue watching. Thank you so much. Arrears of pension contributions. If the employer is insolvent and a receiver, a liquidator, has been appointed, unpaid contributions due from the employer to an occupational pension fund or a personal pension fund can be paid by the redundancy payment service, RSPS. So we are looking at occupational pension fund or personal pension fund and how they might or might not be recovered. So a written application must be made to the RPS by the trustee of the fund for the full amount owed to the pension fund. Employees cannot apply individually. Payment will be made provided that the RPS is satisfied that the employer is insolvent and a liquidator receiver has been appointed and the contributions were due from the employer at the time of the insolvency. If payment is made to the employee from the redundancy payment service and they then recover money from their employer, the payments made from the RPS can be recouped from any money recovered. Stay tuned. Continue watching. Thank you so much. Who can claim? There is no minimum length of time or number of hours a client must have worked for the employer before they can claim from the redundancy payment service? Or is there an age limit? However, there must be an employee and must satisfy the normal qualifying period conditions for the payment they are claiming. The following people cannot claim: agency workers, people who are self-employed, share fishermen, merchant seamen, although they can claim a redundancy payment. Some of this material is subject to revision because there has been a recent election and the government is set to change employment law. So in the coming weeks and months, you visit the internet, pay attention to these changes because they can be fundamentally critical. So how to claim? Stay tuned, continue watching. You don't need the RPI form anymore. When the receiver or liquidator's appointed, they should give you a CN case reference number. So you can use the CN number to apply online for redundancy pay and unpaid wages. The receiver or liquidator should also give you an LLN reference number when your notice period would have ended. So they can use the LLN number to apply online for loss of notice pay. If the client hasn't been given these numbers, they should write to the receiver or liquidator. Pay attention to gov.uk redundancy payment forms and guidance for insolvency practitioners. You can find the registered office on Company House. Stay tuned, continue watching. If the client can't get the reference numbers from the receiver or liquidator, or doesn't know who the receiver or liquidator is, they can telephone the Redundancy Payment Service RPS helpline. The helpline will call the helpline can advise the caller about what they can do. However, the helpline should not be used in the first instance. If the client wants to claim a statutory redundancy payment direct from the redundancy payment scheme, RPS, where a receiver or a liquidator has not been appointed, they can get the reference numbers by telephoning the RPS helpline. Stay tuned, continue watching. Thank you so much. If a company is not formally insolvent and there is no receiver or liquidator, the Redundancy Payment Service may advise clients to go to an employment tribunal for an award of redundancy pay before it considers making a payment. There is nothing to prevent someone making a claim to the redundancy payment scheme service and going to an employment tribunal at the same time. Stay tuned, continue watching. So if the client has neither been paid nor heard anything further about their claim within 3 months of applying, they should write to the Redundancy Payment Service giving details of their claim. The Redundancy payment service usually requires a statement from the receiver or liquidator before making a payment from the redundancy payment services. However, payments can be made from the redundancy payment services without receivers or liquidators statement if the RRPS already knows the amount payable. Stay tuned, continue watching. Thank you so much. So a client can write to the redundancy payment services at redundancy claims, redundancy payment office, which is at Cabot Square in Birmingham in the United Kingdom. Go online and find the details of any information you may need. The telephone number of the redundancy payment office line in England, Wales, and Scotland can also be found online, and you can email them, and they are part of gov.uk. Redundancy payment online at insolvency.gov.uk. These are important information if you are in a situation similar to what we are discussing. So, and looking at tax and national insurance on payments from the redundancy payment services, payments from the redundancy payments services that compensate for arrears of pay, holiday pay, pay in lieu of notice, are paid net of national insurance and tax deductions, and for arrears of pay and holiday pay, tax and national insurance contributions are actually paid. If the client's gross income is less than their tax allowances by the end of the tax year, they can claim back any excess tax they have paid. Stay tuned, continue watching, and also you can look more online about claiming back excess tax. These websites are extremely important. They are public, they are accessible by members of the public. The amount deducted for tax from pay in lieu of notice is called national tax. It is called notional tax because although this amount is not actually paid to the HMRC, His Majesty Revenue and Customs, it is deducted so that any employee who receive pay in lieu is not better off than they would have been, and they work their notice period when pay would have been tax when payment is made. The redundancy payment service will issue form RP9. This shows how the compensatory notice payment has been calculated and how much notice national tax has been deducted. The client should keep this form because in some circumstances they may be able to claim the national tax back. Stay tuned, continue watching. Thank you so much. So if the client grows, the client's gross income in the tax year, which included their notice period, is less than their tax allowances, they can claim the national tax back from the redundancy payment services. The claim should be made after the end of the tax year on form redundancy pay 13, which is available from the redundancy payment service. It should be returned to the address given on the form together with the client's redundancy pay 9 P60 and P60U. P60 or P60U is a statement of a person's taxable income in a tax year and how much tax they are paid in the year if a P60 is not available for example, because it has been lost, the client should ask their tax office for a statement showing the total amounts of taxable income and tax-free allowances for the tax year in which the notice period fell. And stay tuned, continue watching. Thank you so much. They should then send this statement with the RP13, redundancy pay 13. So look at the subsequent earnings and effect on payments from the redundancy pay payment service. Thank you so much. Continue watching. Stay tuned. Once a client has been found to be entitled to a payment from the redundancy payment service, any subsequent earnings they receive from any other job will have no effect on the payment. However, if the client starts another job before the end of their minimum period of notice, the amount of wages earned during that period will be deducted. Stay tuned, continue watching. Thank you so much. And you're looking at registering as a creditor of the business. If the client is not eligible for to claim a payment from the redundancy payment service, or if they are owed money which the redundancy payment service will not pay, they will have to make a claim to the receiver liquidator to get the money back. The job of the receiver liquidator is to sell the business assets and pay the business creditors from the proceeds. But the law does not treat all creditors equally. There is a strict priority order in which such claims must be paid. Stay tuned, continue watching. Thank you so much. The order in which the receiver liquidator will pay the business debts is liquidators' fees and other costs of winding up the business, preferential creditors including employees for non-payment of some wages and holiday pay, and the local authority department of the environment in Northern Ireland for business arrears, secured creditors who have a floating charge on the company's assets. That is people who have lent money to the company where the charge is on a fund of the company's assets rather than being a fixed charge on the specific asset. Stay tuned, continue what you say. Thank you so much. And ordinary creditors, that is creditors who have no security for the money they are owed. For example, customers who are owed money, goods, or services. Stay tuned, continue watching. We're also looking at creditors, secure creditors, that is people who have lent money to the company in return for a fixed charge on assets. For example, a mortgage can look to the assets over which they have a charge to recover their debts. In practice, this means that the secured creditors will recover their money before the assets are distributed according to the order in the previous paragraph. Stay tuned, continue watching. Thank you so much. Let us look at how to claim. To register, a client should complete a proof of debt form available from the receiver liquidator. The receiver liquidator can be contacted through the company's registered office. You can find the company's registered office on the Companies House website, as I said before. Stay tuned, continue watching. Thank you so much. If the employees were in a trade union, a union representative can complete a proof of debt form on behalf of all the members. So we are looking at what the client can claim as a preferential creditor. Thank you so much for watching today's material. Subscribe to this YouTube channel if you haven't subscribed, and if you watch this video, share with family and friends. Click like, click notification bell. See you in the next one. Thank you so much. Bye bye.
MVC record.
Bravo, Jesus!